Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How's it going? Holy hell, we're back to finally having like a normal day, a normal day in my life where I can actually, kind of do the show at the regular time, not have to cut it off, get here on time, which is actually abnormal, but I even got a shower in right before the show. This is great. I feel fantastic. Okay, and we have a big show, I guess. I don't know. Oh, man, I gotta get this little rat tail cut off. Damn. We have a big show for me. I don't care like the numbers. I don't care about anything else. It's a big show for me. Because I have been waiting to see Trump's legal team's arguments and the reaction that will come to them. This is big stuff. Trump's team has filed their petition to the Supreme Court of the United States to review the removal of Trump from the Colorado ballot, presidential election ballot, by the Colorado Supreme Court, using as their justification Section 3 of the 14th Amendment, the quote unquote infamous now insurrection clause, which has no jurisprudence around it surrounding its application to or methodology for application of a president or former president of the United States seeking election as president. Again, this is a highly specific situation, right? Highly specific. I would argue that never in American history, including up to this moment, has any president insurrected against the United States. I will state that with as firm of an erection as possible. Let's just get that out there. All right. This has never happened. It still hasn't happened, but there are a bunch of people who've been desperately trying to convince the public that this has happened. Lincoln did not. You can say that Lincoln did a bunch, whatever. In the legal schema of how this works out, Lincoln remained president of the United States. Texas v. White suggests that all of the rebellion and the Confederacy itself was not legally applicable. All of those states remained part of the United States, and all actions were taken in furtherance of actually suppressing an insurrection. You can debate it all you want. That's fine. You can disagree. That's fine. But that is the legal standing so far. But I would argue that in concept, it's effectively impossible for a sitting president who is not impeached because of his actions to insurrect against his own administration. It just isn't a thing that can work. Logically speaking, you would have to remove their status as president for the insurrection to be validated, which would mean now necessarily you would impeach them after the fact, right? The acts would occur for an insurrection, then the impeachment would occur, removing the president, recognizing the insurrection. Therefore, he's no longer president because of the acts that occurred. Therefore, he can now be tried for insurrection and disqualified under the 14th Amendment. There is maybe, actually, I would say no, but in theory, okay? That's my only logical application for how an insurrection against one's own administration could occur. Because if whatever act you did was not sufficient for removal through the impeachment process, which is the only process due to specific acts amounting to high crimes or misdemeanors against the United States, or its people, the only way to remove a president is impeachment. Imagine if you could subvert the presidency of the United States by being just a district attorney deciding to file criminal charges against the president at any time. Be like, well, insurrection charges for whatever purpose. And then you get a biased jury, you get whatever you want. Imagine it's that easy when they wrote a process that is so damn difficult. How could we sustain this is the question. Now, does that mean it's the answer that the Supreme Court will come to? No. No, of course not. Of course, that is not automatically the answer the Supreme Court would come to. Although it's the answer, I think, that makes the most sense and that properly constrains the judicial branch from overreaching its separation of power obligations in the Constitution. But we will get into all of that as we go. I do not think any president who has not been removed via impeachment can have possibly insurrected against his own government, because if he did, he would be removed from office by impeachment. That's the logical. Well, impeachment's a political process. Okay. But then you have a significant number of senators or a significant enough number of House members that either impeachment is not brought against the president or he's not able to be convicted. If he's not able to be convicted under impeachment, how can he have actually insurrected against the United States? That does not mean people like what he does. That does not mean that what he does is ultimately good or bad or anything, or that it's politically expedient or that it's smart in any way or even sane or logical. But if you cannot remove a president via impeachment, can he have committed such an offense as to be called an insurrectionist against his own administration? That is weird to suggest that that can have happened. Throw this in with Trump, that there was an impeachment brought and it failed to produce a conviction. And it was related directly to the alleged insurrection. So without an impeachment that has succeeded, without a criminal charge that has succeeded, even being made, questionable if they could charge criminally a president for insurrection directly. But without that, without any suggestion that an insurrection has occurred for a president to participate in, and then further with no actual tangible result that we can show, how can we say a president has done that? That is my first logical question for anyone suggesting that Trump participated in or engaged in an insurrection. Enough of the country believes that January 6th was justified, and enough of the representatives believe that either January 6th was justified or that Trump's participation in it was not sufficient to remove him from office as an insurrectionist. Enough of that has occurred that he's remained in office to the very last day. So did he insurrect? I would say no. There is no way. We have nothing to say he did other than a court years later deciding without any sort of full process that he did. But we'll see that in this document. All right. All of that aside, we now have a petition to the Supreme Court to ask some basic questions. Does the 14th Amendment, Section 3, apply to a president at all? Can it? To what extent are Trump's actions actually under there? Does Colorado, does a state in general have the ability to remove a president under Article 4 or under Section 3 of the 14th Amendment? Is that in the purview of Congress rather than the states? And finally, did Colorado actually exceed its own authority on a specific other provision? I'm trying to think of what the wording is. We'll get to it in the document, but basically around how states tally up electoral votes by effectively attempting to disenfranchise, half of the voting public effectively. These are questions that need to be asked, need to be answered, and never, ever have. We're going to find the initial legal arguments or the initial legal petition. This is merely requesting the Supreme Court to take this up. In my opinion, they have to. They have to. Because how can a Supreme Court allow this to be an unanswered question when it has finally been asked? Or all of these questions, really. So, Maine is not included, by the way, in this petition because Maine's process is different and Trump is following the process. Although I think he could have taken it straight to the Supreme Court, he chose not to. So, we will be exploring this. It's a 32-page filing. We're going to go through all of it. This is one of those that I think is absolutely necessary to go through every single word, line, argument, whatever of this document. We're going to try and get all of it done on tonight's show. It is the main and sole subject that I plan to cover. There are a couple ancillary things that I am thinking of covering with it. If it goes super fast, I have other subjects. I know, of course, the list is being released or has been released or whatever. I have stories about Jimmy Kimmel that are really hilarious in the context of what has come out now that I grabbed a couple days ago in regards to Aaron Rodgers. I was prepared to make an entire segment about Jimmy Kimmel having a shit defamation claim because of what Aaron Rodgers actually said. And then it turns out it's a worse defamation claim because it appears that Jimmy Kimmel was actually involved, and he was just trying to lie about that. So that's great. I like that. That's funny to me. But we may get into that. We may not. What I am going to do, since people aren't used to me being on time, is I'm going to tell just a brief story about my day today. It was great. It was funny. And it was fun, and some of you may identify with it, or some of you may be bored titless, and we'll just deal with that as we go. As I have been doing, we're going to take super chats as we go, so I can properly manage time in a better way, and make sure we keep the show going. Of course, if there's a certain point, I may not interrupt it to do a super chat or whatever, but we'll try to keep on top of those. If that changes, I'll let you know in the middle of the show. But it's been working pretty well past couple shows, so that's great. Same with Rumble Rants and Locals Chats. Speaking of Rumble Rant, Ashiara Fan Mike says, on time tax. Well, there you go. Thank you so much. Fire PA 498 says, Nick, how justified are you for all those Stephen Hawking jokes now? I always was justified for every Stephen Hawking joke. And Geg says, Regataloff, thanks for covering this. Of course. This is one of the most important, presently most important legal stories, in my opinion. 1868, I believe, or 1869 would be the ratification of the 14th Amendment. And we have never had this question asked. So now we get it asked, and we're hopefully going to get it answered by the Supreme Court. And the answer, it doesn't matter to me. I mean, I have my preference for how it should be answered, but it really doesn't matter what the answer is in the grand scheme of things, because the Supreme Court will create it. They're going to create law around this. They're going to determine what people who've been dead for well over a fucking century and a half now, meant when they wrote something down, and how that should apply going 150 years into the future. So they're going to make that shit up. Like, they're going to go back and they're going to proof text some fucking arguments about, legislative history and all that stuff, contemporary writings. And then they're going to decide what they want it to say based on a whole lot of stuff, a lot of their own politics, their own opinions about the Constitution. So I have my opinion about how it should go. They'll have theirs. But whatever the outcome is, their opinion will be what makes law. And there are people on both sides of this. Some saying, oh, no way. Of course it applies to a president. Others like, no, it's going to be near unanimous decision, if not unanimous, that it doesn't, et cetera, et cetera, et cetera. So we'll get into all of that real quick. Quick updates. I have reached out to Destiny. He gave me some very broad time frames over the next couple days to see if I can pop on his show and talk kind of about this Trump insurrection January 6th. I will be I'm checking with the lady on where I have time. He streams from like 11 a.m. to 9 p.m. every day, which is insane to me that he's able to do that. But I think he like plays like Factorio or whatever. So he has something kind of going, and then he like brings people in and chats and stuff. He's really good at that shit. I cannot play a video game and like do that. Like I can't do that, but he's able to manage that. So I'm going to try and find a good time slot in the next 2 days to pop onto his show, discuss this specific issue. I don't know if anybody else will be on or not, but I told him I'm not like a huge fan of the internet blood sport type arguments, and that he seems to be a guy who will argue in good faith until someone acts like a dick. So we'll hopefully keep it to a discussion that like is worth having rather than, just I want to win by dunking thing. Of course, I always try to make things entertaining, but we'll try to keep it out of the realm of like, making the debate or discussion pointless. I think it's a good discussion to have. In the end, the main answer is we don't actually know. We won't until the Supreme Court comes down to it, but we can give some good reasons as to why it should be a particular way. So, hopefully I can do that in the next couple days with him. Friday night, I will not be streaming. So that is confirmed. I will not be streaming Friday night. So sorry about that. I've got some plans that were manifesting for a while. They're finalized, and I will not be available to stream that night. But next week we will be in full gear again. And we got a couple more chats, and then we'll get into my brief story about today, and then we will go ahead and hit this topic. Ellie Fant says, clutch pearls and get wrecked haters. Wow. Scarvy the Strange says, will the Dems use AI to prosecute Trump? Yes, they will employ Cohen and his massive AI skills. We're going to do that. Or we'll see the Democrats do that. Okay, brief story. So I finally got to go to my breakfast dinner. My birthday dinner. My kids wanted to take me to a particular restaurant for my birthday, but we haven't had time to actually go to this restaurant. It's not in our town. It's about an hour away, and it's a teppanyaki or hibachi, as some people call it, restaurant where where a Mexican man comes in, pretends to be Japanese, and cooks Japanese food sort of at your table, which is actually just a commercial grill with a table built around it. If you've never had it, it's a fun endeavor. It's great for families or little get-togethers. It's a little, I'm actually not going to say it's overpriced. It's very reasonably priced most of the time. And the food is generally pretty good. It's also right there from the grill onto your plate. So you get it when it's hot. There's no waiting. It's just straight to your fucking gullet from the warm, which is a big benefit. So my kids love going there. Of course, there's a little performative aspect of it. We got to go, and there's 7 of us, right? So we go in and sit down around this table, and they seat us with 4 of these fucking Zoomers. 2 guys, I think, and then 2 girls, I think, who are sitting on this one side of the table. And so then they put us around the rest of the table. It's like, why didn't you just give us our own table? Like, why would you sit us here? It doesn't make sense. But I guess economy of seating, that's how they wanted to do it. Whatever. Did they shoot sake into my mouth? No, they did not. I actually don't. They use a shitty sake for cooking. I don't really prefer that. There are sakes I like, but or sakes that I like, but I don't like doing that at the restaurant. It's pointless to me. It's cooking wine effectively. So we sit down, and right as we get there, these kids, I mean, they're definitely under 21. They're probably about 19, 18 years old, maybe. They're sitting there, and they like huddle up and start. And I'm like, well, that's weird, but I figured it's because we had kids. Maybe they, like were trying to be respectful with profanity or something. I don't know, though. We're sitting there. My kids are being actually angelic, which is kind of surprising because, like we just drove an hour, probably irritated, but they're being very good, very quiet. And we're just sitting there waiting for the guy. And all of a sudden they just pay their bill and fucking leave. It's like, oh, okay. I have no idea yet, but I regard this as a superpower. The ability to clear 4 Zoomers, 2 of them having the shaved sides and the fucking eraser top haircuts right the hell out. They were gone and it was blissful. So then we were able to like move around and be like just right around the front of the table. We basically took it over. It was kind of like Germany looking at Poland, which was good. That should happen all the time. In fact, if I could harness that energy and carry it into every restaurant, I would. But I don't know how to. I don't know how to do that because it's never happened before. But yeah, none of us were even obnoxious yet. I mean, I probably would be after a little bit, but it was great. So that's it. That's all. It's just a little story about those. My kids ended up being great the entire time until the end. Until the end when it was time to go. And now they're all mad, of course, at each other and being like, well, one daughter was mad at one son. My other son was just quiet. And then my 2 youngest daughters were like hugging the entire staff, telling them thank you for making a great restaurant, which was adorable. But it's like, stop it. We need to go. Anyway, it was great. All right. With that, let's get into this topic. I never want to sit by 2 couples that are children ever again. Nick's gay lover says, Nick, Happy New Year. How are the Mondays with Joe? Father streams a tie and other dads, and the Faith Bible Talk and local shows going? Well, hopefully they're going to pick up. The Chad Dad shows got really tough because Doug TeNapel was kicked off of YouTube and I couldn't have him on. And I didn't really want to do that show without Doug. Now that he's back on YouTube and Larry Bladner has reached out to me, I'm going to try and get him going again. It's just my show is really late for all of them. Sometimes it's not as late for Ty, but I would love to do that. And I think we may actually have some big brain panel shows coming back as Mr. Peacock has indicated that soon this year, he may actually be available to come on the stream again, which would be fucking fantastic. I loved both of those shows. As for Mondays with Joe, when I had to cancel like 15 of them in a row, it felt like it wasn't really, but I kept having to cancel the Mondays with Joe because I wasn't available during Joe's time slot. Hence why I stream at 11 and not 9. When Joe streams at 9, I'm not always around at 9 to do a show. When it became apparent that I couldn't actually keep a consistent schedule with him, we both announced that we would be putting that on hold. If we could get back to it, I'd love to. I love talking to Joe all the time. It just doesn't work out when I'm not home at 9 o'clock. Or if I am home, I don't have the capacity because I'm doing other things. So there's a reason my show has been at 11 forever, although I am looking to change it. But since that was a big part of it, being able to go on Joe's show before mine, it didn't really feel right to have this agreement that I couldn't keep most of the time. The Father stream. Oh, wait. And the Faith Bible Talk on locals, still working up exactly how I want to do that. But again, I'm slow to get things going, but hopefully this year I can. It's just that the last half of my year turned into a fucking cluster on schedules. Randall McCollum says, don't have to read this out loud. 2-minute quarter interaction in Vegas. I think the chat would enjoy. Not need to watch it all. If it's not that flying fucking lariat of a judge, I'm going to be all legitimately pissed at you. This might be the way we have to warm this show up for the Trump document. It is. Oh, yeah. Okay. We're watching all this. I don't care what anybody says. Here we go. If you have not seen this yet, steel yourself. This is a man who is being sentenced for assault. I mean, shockingly. And this is what happens in court during the sentencing. This makes me
to do probation successfully given this opportunity. I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court.
Oh shit! We gotta have an instant replay.
This court.
Here's me. RKO out of nowhere!
This
one more time. Oh my god. How does that even happen? How does that even happen? How do you fail? Like, how does everybody around that guy fail that hard? My man comes running, leaps, and you gotta like the judge is typically up on a dais already. He's already up on a dais, or the judge is already up on a dais. So there's an extra amount of elevation. So this homeboy leaps like a Mongolian catapult over the Great Wall, launches himself into Lady Judge, who's just about to drop that. I think he gets a little taste of it. And he probably deserves the taste of justice, right? He probably deserves it. But he's like, not today, Galvatron. Just flying lariats like King from Tekken 3 over the goddamn bench. And she gets clapped right into the wall, too. I kind of feel bad for her, but it's too funny of an image to not laugh at. Even if you feel bad for the judge, I think they should release, I think they should release him just because it was so damn impressive. Oh, my God. I know they can jump. I know they can jump, but it's still look, when Jordan would dunk, it was still impressive. It's like, I know he can do that, but oh damn, every time it's amazing. It was that was something. That was something. It was a thing of beauty. It was a perfectly executed move. He had to dodge so many people. He had to be like Deion Sanders, like in multiple sports here. He had to get around he had to dodge all of the fucking court staff, lawyers, bailiffs, who are all fat anyway. Like, they don't move very fast. And then he has to make that jump confidently over the bench, over a computer monitor. I mean, can we just, let's see. We gotta, he clears this whole thing with ease. He's way more than an Asian penis over that monitor. This guy is levitating into the judge. Whoo. Oh my God. Why is it so hard to get people to dress nice for court? This guy's about to get sentenced for assault. He doesn't give a shit. If he was in a suit, he would have caught that monitor and probably failed. Look at the zenith of this jump. Oh my God. Is he? Guys, look at how much more impressive this is. My man, my bald guy at the bottom right down here, he gets a hand on the foot because otherwise the feet would have gone over, right? He gets a hand on the foot, and actually that's what slows his lower body down because his upper body is 2 feet higher. His upper body is 2 feet higher than his waist. His waist was going up with it. But the guy gets a hand on the foot, slows the momentum, and it kills the whole jump. This guy was jumping like a motherfucker. Oh my God. Look at the court clerk's face over here. Oh. It's like he can see the future and how impressive this jump is going to be. This guy's probably jumped over like 15 Popeyes counters in his life. He's been like, I trained my whole life for this. And then look at I mean, I would not want to be the judge here. She gets clobbered into that wall. Oh, there's the head hits and bounces. She's probably got a concussion. Because that's like 200-pound dude coming in hot from 7 feet up. Blam! Her head hits. Oh, jeez. And then this guy, he's probably in his ineffectual whiteness, he thinks he's going to help the judge here. But what he actually does, he alley-oops this man into the judge even harder with his pudgy body weight right here. And he takes that butt at the same time. He did everything. The judge her head is ping-ponging off the wall because of the court clerk. He doesn't help anything. Terrible. And then she hits so hard that she bounces back the other way. God. And then he collapses on her again. Why is... And America has fallen. Oh, God, I think it's against my ethical obligations to laugh at that, but I can't stop. Oh, yeah, I loved it. I love that. Okay, yeah, save that. Can I open the... I want to open the file. Anyway, that helped me. That helped me. Man, I love that. Oh boy. You don't get to see that every day. Where do you get this? Where does that happen? Not enough. All right. Okay, here we go. Outpost Nerd says that dude who attacked the judge rolled a nat 20 on his agility check. Oh. Emag says Holthus, I guess the judge, suffered a minor head injury, but was doing okay, sources told the outlet. A marshal was also injured in the fracas. Savage Gerbil, ethics question. She was about to sentence. Would she need to recuse herself for sentencing after the incident? Her sentence is probably already written and may have even been entered in a written order. If that's the case, no. I think also no. I don't think that would actually be grounds for recusal, because she would separately punish for the contempt of court, or a separate charge would be done for the assault. All right, here we go. Next. Nice podcast. Stupid says, hey, Nick, are you still trying to pretend like you didn't get catfished by a 42-year-old dude? Lay off the booze, dummy. Pretend what? Now, I'm not pretending anything, although I don't know exactly what you mean by catfish, but I guess we'll find out, won't we? Or we won't. Who knows? Fire PA says, did they get to play that video at whatever trial has next for trying to yeet the judge? Yes. Yes, they do. Stephanie D says, justice would have been the flag coming down early and bailing that asshole. Oh, why? What did he do wrong? What do you got against that guy? Bringing justice to the streets. Here we go. Let's see. Do we have anything else? Yes. Romulox says, Nick, please set up the debate with Destiny. Content Gold, man. He just mentioned you on his stream. Cool. Yeah. I mean, he sent me his schedule and I was like, oh, okay. I'll see what I can work out. Working on it. I think we will have it set up soon. That's the goal. I just have to check my schedule the next 2 days here and figure out where it fits in. All right, here we go. This one. Different. Here we go. Here is the Supreme Court petition. So this is a petition for writ of certiorari. I don't know how to say this Latin word. It just means Supreme Court, please hear my plea, hear my cry. Supreme Court, hear my cry. To the Supreme Court of Colorado, petition for writ of cert. And we have all of the lawyers here. Question presented. The Supreme Court of Colorado held that President Donald J. Trump is disqualified from holding the office of president because he engaged in insurrection against the Constitution of the United States, and that he did so after taking an oath as an officer of the United States to support the Constitution. Notice they have as an officer of the United States in quotes and support in quotes. This is an indication of exactly where they're going to go with this. Carol says that was just bail hearing. He wasn't getting any. Oh, wait, I thought he was, I thought that was a sentencing hearing. Maybe I read wrong. Well, cool. Thanks for the update on that. The state Supreme Court ruled that Colorado Secretary of State should not list President Trump's name on the 2024 presidential primary ballot or count any write-in votes cast for him. A lot of people have asked about, can you write him in if he's not on the ballot? No. No. That state, well, I shouldn't say no. I shouldn't say no, because this is a confusing question, right? How can you accept write-in votes if you've determined the president to be disqualified, right? So in theory, you can write in for the president, but if you've determined he's disqualified from voting, you can't accept write-in votes for disqualified president. So that wouldn't work. That state is effectively saying Donald Trump cannot in any circumstance be president of the United States. He cannot, except he could, in theory, still win without Colorado or Maine, right? Like that can happen. He's not likely to win Colorado or all of Maine anyway. He could still win the country. And then what happens? Colorado doesn't recognize his legitimacy as president. Neither does Maine, but yet the other 48 states would. This is why the 14th Amendment, Section 3, is so quintessentially unworkable in the manner in which it's being applied. All of these questions come in, and none of the answers can possibly make sense if you say a state has the ability to disqualify a president from their own ballot based on the federal Constitution. Either a president is, or a candidate is qualified to be the president, or he is not. There cannot be a middle ground. There cannot be a hodgepodge of answers. It doesn't make any sense. We don't run the country with a hodgepodge of answers on national issues. When we do, eventually the Supreme Court steps in because there's a circuit split, but it's certainly not on anything like this. Usually we have conflicts of state law application, not federal law application, and certainly not constitutional questions. How can two states exist in the union without being able to recognize the legitimacy of the commander-in-chief? Like, let's just assume Trump wins without Colorado and Maine, without being on the ballots because they invalidate him. How does it work? How can they remain in the union? They necessarily cannot consider him the president, right? Like, they can't do it. You can't just be like, well, we lost. No, you said that he can't be president. So how? How? All right. The state Supreme Court stayed its decision pending U.S. Supreme Court review. The question presented is, did the Colorado Supreme Court err in ordering President Trump excluded for the 2024 presidential primary ballot? The only answer, the more and more I talk about this, think about it, and work through it in my brain, the only logical conclusion is, of course, they erred in removing him from the ballot. Now, should Trump be removed from all ballots, from being able to hold office, is a different question than what is presented here. I still say no, he should not be removed from any ballots. He's definitely qualified to be president. And Section 3 of the 14th Amendment does not apply. And even if it did apply to presidents, generally would not apply to Donald Trump. So obviously that's my opinion. But just going based on this legal question, there's no way this can possibly be how this works. Something else has to occur. Parties to the proceeding, Donald Trump, blah, 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 blah. I don't really care about the parties. So I said I was going to read all of the petition. I am, but I'm not going to read all the parties because it doesn't matter here for our purposes. Statement of related cases. Counsel is aware of no directly related proceedings. So this is the only case that is covered here. Here's the table of contents. We're going to skip this. It has clues to where it's going. It's fine. The table of authorities. all the constitutional provisions, all the statutes involved that they cite, all the cases that they cite, and here are the extra authorities that they cite. These would be like legal treaties, law review articles, stuff like that. So we are going to go into, however, this, which will give us actually all of the information that we need. Those are just, the table of contents is just there for the ease of the clerks who are going to have to organize the justices' papers and citation, or the justices' writing and citations on the issue. All right. Donald Trump, petitioner, versus Norma Anderson et al. Respondents on petition for writ to the Supreme Court of Colorado. Petition for writ of cert to the U.S. Supreme Court. It is a fundamental principle of our representative democracy, embodied in the Constitution, that the people should choose whom they please to govern them. And I'm not gonna go into doing this as often as I should, but there is, we'll do this really quickly because it's such a pointless article, and it won't take any time at all. Oh my God. I fucking hate this. Just a second. All right. Okay, just a second. We have this article from Raw Story with an NBC analyst, a legal analyst from NBC, who has determined that this petition is garbage. So I'm archiving it right now because it's being a bitch. So in the meanwhile, we'll go on and we'll look at their criticisms. It's really short. It says, it's fundamentally flawed. It's legally bad. And of course, they don't tell you why at all. They don't tell you. But that the people should choose whom they please to govern them. U.S. Term Limits, Inc. versus Thornton, quoting Powell versus McCormick. These are 1995 and 1969 cases. Petitioner President Donald J. Trump is the leading candidate for the Republican Party nomination for president in the United States. And then we have the Real Clear Politics poll. He's polling way ahead of everybody. Over 74 million Americans voted for President Trump in the 2020 general election, including more than 1.3 million voters in the state of Colorado. Yet on December 19th, 2023, Colorado Supreme Court ordered President Trump removed from the presidential primary ballot, a ruling that, if allowed to stand, will mark the first time in the history of the United States that the judiciary has prevented voters from casting ballots for the leading major party presidential candidate. Really, it'd be the first time ever. Not just that the judiciary has done it, but the first time anyone has done it. In our system of government, of the people, by the people, and for the people, Colorado's ruling is not and cannot be correct. I agree. This court should grant cert to consider this question of paramount importance, summarily reverse the Colorado Supreme Court's ruling, and return the right to vote for their candidate of choice to the voters. The question of eligibility to serve as president of the United States is properly reserved for Congress. No, I don't disagree with this based on how they proceed. So we'll see how they argue this. And I think they agree with how I take this. Not the state courts to consider and decide. Because in theory, Congress could go ahead and, pass an amendment to change the eligibility of a president. And also in theory, they could, under Article 5 or Section 5 of the 14th Amendment, create a law around the insurrection clause. But we'll get to that. By considering the question of President Trump's eligibility and barring him from ballot, they could also impeach him. Barring him from the ballot, the Colorado Supreme Court arrogated Congress's authority. So we have these federal elections results, and then we have the Gettysburg Address, of course, is the quote here: government of the people, by the people, and for the people. In addition, even if the Colorado Supreme Court could consider challenges to President Trump's eligibility, which it cannot, it misapplied the law. First, the president is not an officer of the United States. He took a different oath than the one set forth in Section 3, and the presidency is not an office under the United States. Thus, President Trump falls outside the scope of Section 3. We've been talking about this over and over. I just wanted you all to know that my assessment of this is not insane. It doesn't make it right. They could be told they're wrong by the Supreme Court, absolutely. But there are plenty of other lawyers who have taken this approach here. I am not alone. Let's take a quick look, though, at this beyond the pale and legally wrong expert shreds Trump's Colorado appeal. So I want you to know, Raw's story has determined that this expert, thank you, Kathleen Cuntington, she has said that this expert is shredding Trump's Colorado appeal. Let's see how he shreds it, okay? Let's take a peek at that. Donald Trump's much anticipated appeal to Colorado's decision to bump him from its ballot shocked a legal expert who professed himself stunned by its shoddiness, he said. The sort of gall that the brief represents, it's really, I think, shocking. Andrew Weissman told Lawrence O'Donnell on MSNBC Wednesday night, it's really sort of beyond the pale and legally wrong. So you can already tell how this is going. What's beyond the pale? What's legally wrong? Weissman, an MSNBC legal analyst and former federal prosecutor, that's 2 cuck strikes against you, bitch. Go die in a hole. Slam Trump's attorneys' arguments for both their arguments and their organization. Okay, there are some legitimate arguments, but they're buried in there, Weissman said. All right. Weissman quickly contextualized his characterization. I'm not saying legitimate like they should prevail. Then pointed to an opening argument he found fundamentally wrong. He found this fundamentally wrong. His lead of argument, I think it means lead off argument, is that the Constitution of the United States says that the people can elect anyone they want. No, Weissman. His lead-off argument is actually citing to a 1995 case, citing a 1969 case about the ability of the populace to choose a president. The courts have decided that. And he also says that's not true. There are restrictions and qualifiers in the Constitution. Yes, there are explicit restrictions and qualifiers, but look at how dishonest this is. He's completely mischaracterizing that argument because he's saying that because you have to be 35 years old or older, you have to be a natural born citizen, you have to reside in the United States for 14 years. Because of those qualifications, the people, then they can't pick whoever they want. It's like, well, that's not what they're saying, though. They're saying that no one should have the ability to constrain an eligible candidate outside of very rare circumstances. Weissman does not point out, well, then why are you mentioning it? That Trump questioned former President Barack Obama's eligibility over erroneous claims he wasn't a U.S. citizen. Again, this is a clear and obvious and open and notorious way to disqualify a president explicitly under a constitutional requirement. That's not what they're talking about. Weissman did say of the claim, that's without irony. Well, what's ironic about it? What would the ironic part of this be? What Weissman found ironic was Trump's professed fears of disenfranchising 1 million Colorado voters. Okay. Why is that ironic? Doesn't make any sense. He notes Donald Trump is charged with essentially trying to disenfranchise 80 million people. Except he isn't. He isn't actually charged with that at all. And he didn't do that in any way. So that's him shredding it, by the way. That is the quality writing you're getting from Raw's story and the quality legal analysis from MSNBC's legal expert on this brief. So that's that. That just so you know, that's a shredded their petition here. Now let's get to the actual legal arguments again, because look at that. That was the whole story. That was the entire article, guys. That was it. He shreds it. Just shreds it. Wait. Where does he shred it? Let's see. So here we go. Not an office under the United States. Thus, President Trump falls outside the scope of Section 3. Colorado Supreme Court erred in how it described President Trump's role in the events of January 6, 2021. It was not insurrection, and President Trump in no way engaged in insurrection. Third, the proceedings in the Colorado Supreme Court were premature and violated the Electors Clause. Finally, There are many other grounds for reversal, as many scholars have pointed, including the 3 grounds for reversal presented in the petition for cert filed last week by the Colorado Republican State Central Committee. So opinions below. The state Supreme Court's opinion is at 2023 Westlaw 8770111 and is reproduced here. The district court's opinion is here and is reproduced there. Whatever. So we have these experts. C. Samuel Moyne, Supreme Court should overturn a Colorado ruling unanimously, from the New York Times. Lawrence Lessig, the Supreme Court must unanimously strike down Trump's ballot removals in slate. Richard Epstein, oh my God, misguided disqualification efforts, defining ideas. John Harrison and Saikrishna Prakash, if Trump is disqualified, he can still run, from Wall Street Journal. Kurt Lash, the meaning and ambiguity of Section 3 of the 14th Amendment. So here are the experts that they're citing just in that statement. So jurisdiction, the state Supreme Court entered judgment. President Trump timely filed this petition. This court has jurisdiction, of course. The Supreme Court has jurisdiction to review state court decisions on federal issues. Damn it, just a second. I lost one of my windows. Over the last few months, more than 60 lawsuits or administrative challenges have been filed seeking to keep President Trump from appearing on the presidential primary or general election ballot. The common theory behind these lawsuits and challenges is that President Trump is somehow disqualified from holding office under Section 3 of the 14th Amendment because of an allegation that he, quote, engaged in insurrection on January 6th. And I mean, it's not just that people are making this claim. The media is running with it as if it's true, like as if this is a foregone conclusion. Well, of course he did. Of course that was an insurrection. Of course he did it. Of course this is the thing. Now we just need people to acknowledge it. Of course that was all how it went. Let's see. Courts considering these. Well, we do have the citation here. William Baud and Michael Stokes, Paulson, the sweep and force of Section 3. This is not actually published yet. Courts considering these claims, including state Supreme Courts in Michigan and Minnesota, have all rejected them for varying reasons, contrary to the Colorado Supreme Court's ruling of December 19th, which ordered the Colorado Secretary of State to exclude President Trump from the presidential primary ballot. The court stayed its ruling until January 4th and announced that the stay would automatically continue if President Trump sought review in this court before that date. The respondents in this case include 6 individuals eligible to vote in Colorado's Republican presidential primary, the Anderson litigants. They are petitioners in the state court proceeding, but respondents in this court. Secretary Griswold is a respondent in both the state court proceedings and this court. To avoid confusion, we will use the parties' names rather than their status. Who sued Colorado Secretary of State Jenna Griswold in state district court, claiming that Section 3 establishes a constitutional limitation on who can run for president. The Anderson litigants sued under Sections 11113, Section 1, and 141204, Section 4 of the Colorado Revised Statutes. Section 111131 allows an eligible voter to sue any person charged with a duty under the Colorado Election Code, but only if that person has committed or is about to commit a breach of it or neglect of duty or other wrongful act. And Section 14, Anderson versus Griswold. So here's the statute. When any controversy arises between any official charged with any duty or function under the code and any candidate or any officers or representatives of a political party or any persons who have made nominations, or when an eligible elector files a verified petition in district court of competent jurisdiction alleging that a person charged with a duty under this code has committed or is about to commit a breach or neglect of duty for other wrongful act, after notice to the official, which includes an opportunity to be heard, upon finding of good cause, the district court shall issue an order requiring substantial compliance with the provisions of this code. The order shall require the person charged to forthwith perform the duty or to desist from the wrongful act or to forthwith show cause why the order should not be obeyed. The burden of proof is on the petitioner. That's a lot to take in, but it basically just says you can force the courts to make an official act in the way they're supposed to under the law. It's effectively a writ of mandamus. But, and they use this. And they quote unquote won on this issue. So here we go. The other statute specifically authorizes an eligible voter to challenge the listing of any candidate on the presidential primary election ballot under the procedures in 113 Although Section 1204 imposes additional rules for these types of lawsuits and demands they be resolved with extraordinary speed, they must be filed with the district court within 5 days of the filing deadline, heard within 5 days of the filing, and the district court must issue findings of fact and conclusions of law within 48 hours of the hearing. None of this is actually relevant to the decision that was made, but they're thoroughly briefing the procedure. Nothing in Colorado's election code requires the Secretary of State to evaluate the qualifications of presidential primary candidates. Correct. It's not actually the job of the Secretary of State to do this. Eligibility is asserted by a presidential primary candidate. And until they are found ineligible somewhere else, the Secretary of State is to presume that they are eligible. Instead, the Colorado statutes require a presidential primary candidate to submit a notarized statement of intent. This statement of intent form, which appears on the Secretary of State's website, requires presidential candidates to affirm that they meet the Constitution's age, residency, and natural-born citizenship requirements by checking the following boxes. Here they are. The statement of intent form also requires candidates to sign an affirmation that they meet all qualifications for the office prescribed by law. A signature line appears below this affirmation along with an unfilled notarial certificate. Colorado laws imposes no duty on the Secretary of State to verify or second-guess the candidate's sworn representations or to exclude presidential candidates from the ballot if the Secretary disbelieves or disagrees with the candidate's sworn representations. You would have to go about this a different way. Again, they cannot leave a presidential candidate's viability as a candidate in the hands of the Secretary of State. The only way they could possibly exclude a presidential candidate is if their representation on one of the three main qualifications from the Constitution, which are explicit, was explicitly in doubt. Explicitly. A 25-year-old representing that they're over 35 would be pretty easy to verify and challenge, right? Not that hard. You could notoriously and openly challenge this. The Secretary of State doesn't have to make a determination. There's no discretion. There's nothing here other than a specific statement that they cannot be president, therefore they cannot be a candidate. If a president was impeached and then subsequently prevented from holding further office, that would be similarly notorious, and the Secretary of State could exclude them. But only because it would be filed and recorded and officialized at some point. Okay. The Anderson litigants nonetheless insist that Secretary Griswold has a mandatory duty to enforce Section 3 of the 14th Amendment, regardless of what state law might provide. And they derive this duty from the Secretary's oath to support the U.S. Constitution. They also incorrectly claim that any decision to include President Trump on the presidential primary ballot would violate the Constitution, therefore qualify as a breach or neglect of duty or other wrongful act within the meaning. And this is just a ludicrous argument in general. The citations are just to the case, the underlying case. Therefore, they sued for relief under Section 113, which authorizes the state district court to issue an order requiring substantial compliance with the provisions of the election code. District court proceedings. Anderson litigants filed their petition on September 6th. The district court did not, however, hold a hearing within 5 days of the filing as required by 1204. Instead, the district court held a status conference on September 18th after the statutory deadline for the hearing had passed, and it scheduled a 5-day hearing to begin on October 30th, 54 days after the petition's filing date. Then the district court denied the motions to dismiss filed by President Trump and the Colorado Republican State Central Committee, which had intervened in the case. So they're stating that obviously they violated the law in how they actually undertook the procedure. And if they do that, then how could this be legitimate in the first place? To me, this is a much less important question other than, do they even have the ability to hear and decide this question? I say no. But we have this footnote here. These are just citations to the case. Anderson litigants also brought a claim for declaratory relief against both the Secretary Griswold and President Trump, but dropped this count after Trump moved to dismiss, which doesn't really matter here either. Okay, so here we go. Footnote here is just, again, to the case itself. The district court denied President Trump basic discovery tools, including the opportunity to depose experts or potential witnesses, compel production of documents, or receive timely disclosures. And the compressed time frame gave President Trump only 10 days to identify and disclose his rebuttal witnesses and 18 days to identify and disclose his rebuttal experts. So we have a due process problem here, they're claiming. And the real problem here would be if the Supreme Court were to determine that Colorado actually could hold a hearing on this and exclude a president under Section 3, they would say that he did not receive the actual process that was due. Therefore, the order should be vacated and remanded for further proceedings, I would guess, or just vacated in general. This is the, if you somehow find that this applies, well, they still fucked up argument. District Court held a 5-day hearing that ran from October 30th through November 3rd, but the District Court did not issue findings of fact and conclusions of law within 48 hours of that hearing, as required by Section 1204. Instead, the District Court held closing arguments on November 15th, 12 days after the conclusion of the hearing, and issued findings of fact and conclusions of law on November 17th. The District Court's finding of fact rely heavily on the final report of the Select Committee to investigate the January 6th attack of the United States Capitol, which the court admitted into evidence over President Trump's hearsay objections. The district court also relied on testimony from Peter Simi, a professor of sociology at Chapman University, whom the district court qualified as an expert on political extremism and the communication styles of far-right political extremists. Oh, I guess I can blow this up. The district court based its finding that President Trump intended to incite violence on January 6th on Simi's analysis of Trump's history with political extremists, as well as Simi's opinion that Trump developed and employed a coded language based in doublespeak that was understood between himself and far-right extremists while maintaining a claim to ambiguity among a wider audience. Can you fucking imagine? Can you imagine that sentence being seriously taken by a court? That sentence, well, he has a history with political extremists. And Donald Trump, a person they regard as like the dumbest person alive, created a coded doublespeak with a secret decoder ring from all the far-right extremists. And he was able to speak where no one else knew about an insurrection, but they all knew exactly what he was talking about because they all ate the same fucking Apple Jacks box in January of 1978. How on earth is this in any way acceptable? In any way acceptable. The district court also relied on Simi's testimony, and this guy's just a sociology professor. Cool. Simi's testimony in finding that President Trump's speech at the Ellipse on January 6th was specifically intended to provoke a violent response from his audience. Simi conceding that he relied exclusively on public speeches and the January 6th report to opine on reactions to President Trump's words. He conducted no research, interviews, or fieldwork of his own. He also disclaimed any opinion on President Trump's intent or state of mind, according to the district court. As Professor Simi testified, Trump's speech took place in the context of a pattern of Trump's knowing encouragement and promotion of violence to develop and deploy a shared coded language with his violent supporters. An understanding had developed between Trump and some of his most extreme supporters that his encouragement, for example, to fight was not metaphorical, referring to a political fight, but rather as a literal call to violence against those working to ensure the transfer of presidential power. Trump understood the power that he had over his supporters. There we fucking go. Beautiful. Beautiful. Excellent conjecture made of absolute cockamamie bullshit. Absolute bullshit. Like the so to put this comparative to law around like incitement, threats of violence, you know, the actual comparable law that we would use, idiomatic language is not generally acceptable as a compelling reason to convict, because you cannot determine the intent of the idiom without further evidence of that specific intent, not further inferences, because someone ideologically, politically, or even intelligence-based opposites of the accused would come to a different conclusion necessarily on their use of idiomatic language. So when you say, we're going to go fight like hell for our country, you have to fight for your country, that does not mean for some people to go and literally fist fight someone for the country. That doesn't make sense to a lot. But other people are pretending it did make sense and that he was actually calling them to go engage in a physical fight for the country. No one knows how they would win the country. Like what level of physicality this group of speech listeners would employ to actually win the country. But that's what they meant, apparently, because this guy knows that that's what he meant because he just does. Because Trump is very, very smart with the best words, obviously. Obviously. Toxic Brute says, Nick, if you haven't already, can you give a toast to Az? Surprise, I haven't heard one yet. Hashtag rip Az. What are you talking about? Az is still alive. What happened to Az? Now I'm curious. Did he get yeeted or something? From something? He's still on Twitter. Yeah, they're fine. Anyway, I don't get it. All right. It's a meme. Good. Well, yes, I will give a toast to Heel versus Babyface, who deprived himself of all essential things, sugar, alcohol, not lifting weights, and probably, he deprived himself of a sedentary and unhealthy lifestyle, and he paid the ultimate price for it. May he live on in the halls of Elysium with the other heroes playing World of Warcraft for eternity. Cheers, brother. All right. There we go. We are going to make the move. We're going to make the move over to Rumble right now. From YouTube, we're going to say sayonara to YouTube. We're going to move over to Rumble, and we're going to keep the show going at that point, but exclusively on Rumble. If you want to join us, the link is pinned in the chat. It is also in the description on YouTube. Come hang out with us over there. We'll have a short break. We need to go to the bathroom, and we will get back into this document and carry on. We are actually about halfway through almost halfway through the PDF, but we'll be moving through it pretty quickly, and then we'll do a synopsis of it. I am very confident that we will get this thing done within the show time, and we may even get to another story, but we're moving very well so far. We will got the burps going. We will see you over on Rumble, and then there will be a brief break, and we'll continue. To all of the YouTube people who've been watching, thank you so much. By the way, big shout out to Joe Neerman. Good Logic raid. Much appreciated. I didn't see when the raid happened. I saw a little bit after in the chat. Thank you all for watching. We'll see you all on the Rumble side. Hopefully. Peace. Peace.